Hi, I'm Don Davis. I'm a securities lawyer. I've been a securities lawyer a long time. I'm here to talk about 506C, the new SEC rule that's just about to go into effect. And today we're going to compare it with the crowdfunding legislation. Now, we don't have crowdfunding legislation issued in the rule form by the SEC. They're studying it, they're looking at it, they're dragging their feet, they're whatever. But we do have some parameters of what it's supposed to be from the Jobs Act. Remember, it was passed by Congress with a mandate to the SEC to put this into place. And although they've dragged their feet, they still have to honor that mandate. And it's probably going to come sooner or later now that we've got a new SEC chairman. Well, so I'm going to compare very briefly 506C and some of the relevant elements with crowdfunding as we understand it in the Jobs Act as adopted by Congress. Because this is important. I want you to understand, there's been a lot of excitement about crowdfunding. I want you to understand just how little significance it is compared with 506C, this new rule that is in place and we do have that we can use, which is going to be a sea change for the securities law in the industry. Okay, so here we go. So 506C is about public offerings, not public sales, but public offerings. And so is crowdfunding. They both permit public offerings, and that's a good thing. That's where we start. That's a relaxation of the SEC rules that have been in place since the Securities Act of 1933, a big sea change. But beyond that, the rules are very different indeed. The crowdfunding rule, of course, allows you to sell to anybody. They don't have to be accredited. But that might sound pretty good, but the reality is that you can only sell little amounts to everybody. That is to say, if there's a test in the crowdfunding legislation, at least in the Act, that says that it's sort of a 5%, 10% rule. You can invest 5% of your net worth if you got under 100,000 or in net worth or income. You can invest 10% with some limitations if you have over 100,000 in net income or net worth. But you can only invest these limited amounts. So the whole idea is you're going to get a lot of money, a lot of money in the forms of dribs and drabs from small people in little amounts. Now, the 506C rule, on the other hand, unlimited in terms of the amount of money you can take as long as they are accredited. And we'll go in another tape and talk about what accredited means and how you prove up accredited in the new standards of 506C. All very easily to comply with, not a problem. We can get around those, I mean, we can solve those issues and document it and make sure you're in compliance with the 506C requirements. 506C has a Reg D notice. It's way more strictly construed. You have to file your offering document. With crowdfunding, there's not a Reg D notice filing, but you have to make available financial statements, and there's some limited filing there. And of course, you have blue skies laws in the various states that you have to comply with, probably in terms of notice filing, paying fees, and so on. But the big difference that makes all the world of difference to me in these two rules is that with crowdfunding, you can raise a total of how much? Did I hear? How much? $1 million in 12 months. Well, that used to be a lot of money in my dad's time. I'm telling you, it isn't very much money today, as we all know. How much money with 506C? Unlimited. You heard me, unlimited, as much as you want. Very good. So that's why 506C is the dynamite rule here to think about and not the crowdfunding rule. So one final comment to think about. Under 506C and under crowdfunding, under both systems, you're subject to Section 10B and Rule 10b-5 of the 34 Act and similar requirements of the 33 Act. What's that mean? It means you got to have an offering circular. You got to cover all the material information, and you can have no material omission in what you tell people. That's where I come in. I'm the securities lawyer. I help you prepare those. We make sure we stay out of trouble. We stay out of private litigation. We stay out of SEC enforcement actions. We make sure things get taken care of in that area. So I'm Don Davis. I'm a securities lawyer. I'd love to talk to you. I'm glad to spend an hour and hear about your deal. I want to hear you about your deal. Call me, please. Tell me what you're doing. It's an exciting area. It's an exciting time to be in this business. Thank you.